Mr. President,
Order. Ms. Sue Higginson.
Mr. President, I move item 57, standing in my name. This is a motion that asks the House to call on the government to do justice. It is calling on the government to issue advice to the Governor to pardon Kathleen Folbigg immediately and to ensure that she is released without delay. This is about acting in the face of the gravest injustice. Kathleen Folbigg is in prison here in New South Wales right now, and she should not be. The person who has the power to change this is the Attorney-General. Kathleen Folbigg was convicted after being found guilty of charges resulting from the deaths of her 4 children, which occurred one at a time over 10 years when they were all just babies. Kathleen was sentenced to imprisonment for 40 years, which was reduced on appeal to 30 years with a 25-year non-parole period. She has served 20 years. The legal system is about evidence. A recent inquiry demonstrated that there are natural causes of death for each child, and Kathleen's diaries that were used against her are not confessions of murder. This is the view taken by the 3 counsels assisting the judge, and the Director of Public Prosecutions has also confirmed this position. There is now a mountain of evidence that was not presented in the trial of Kathleen Folbigg, nor in subsequent inquiries, that now shows there is reasonable doubt as to her guilt and her convictions. Mr. President, I'm moving this motion because the Attorney-General has the power as the first law officer of this state to free Kathleen Folbigg. It's important to understand the inquiry into Kathleen Folbigg's conviction is a separate process to the one available to the Attorney-General. The Attorney-General's power to do the right thing is not at all contingent on the written document that will come at the end of an inquiry. The inquiry was ordered by the former Attorney-General Mark Speakman after he received a petition requesting a pardon from Kathleen's legal team. The inquiry is Mr. Speakman's inquiry. It is not Kathleen Folbigg's. She asked for a pardon and is still asking now, and this House must join that call. The evidence heard at the recent inquiry in no uncertain terms supports Kathleen Folbigg's position that she has always maintained and that she was wrongfully convicted in 2003. Mr. President, the Attorney-General does not need to wait, and nor should he wait, for the written document from the inquiry. It could take the inquirer days, weeks, months before he's able to get the final document published, and that's how that part of the system works. Written work can't be rushed. It takes time. It can take weeks, months, and for all sorts of legitimate reasons. In 2003, Kathleen was convicted after a trial that relied on coincidence, tendency, and it was strongly influenced by a since discredited Meadows law, a precept espoused by a controversial paediatrician, Roy Meadow, suggesting that 3 or more sudden infant deaths in one family was murder until proven otherwise. The G114R variant in the CALM2 gene, which is predicted to cause lethal cardiac arrhythmias, was found in both of Ms. Folbigg's and her 2 baby daughters. In 2021, a senior paediatric neurologist concluded that Kathleen's baby son likely died of an epileptic seizure. Baby Caleb, her first, the death was always diagnosed as SIDS. He was just 19 days old, and it's been well documented that he was a very unwell baby. Now we have compelling psychiatric evidence providing much more honest and unbiased and realistic view of Kathleen's diaries and her state of mind and her grief at the time. Counsel assisting the inquiry, Sophie Callan, said the overwhelming weight of evidence suggests that Miss Folbigg was a loving and caring mother towards her children. And as the judge himself said in the inquiry, there is now a significant body of evidence to suggest reasonable possibilities of identifiable natural causes of death that were not available at the trial. The government's Attorney-General has the power to act now. He's the only person who currently is keeping Kathleen in prison wrongly. When you have legal power vested in you, you either exercise it. It is wrong in all of the circumstances for the attorney not to exercise his power right now. Every minute he delays the administration of justice for Kathleen, he offends the very notion of the rule of law. Kathleen is a woman like Lindy Chamberlain who has been failed by the criminal justice system. We cannot undo the past 20 years for Kathleen, but we can act here and we can act now. Please, members, support this motion for Kathleen, for all the women and for all the people of New South Wales.
The Honourable Robert Borsak.
Thank you, Mr President. I rise to add my voice to advocate for the parole or pardon of Kathleen Folbigg, a woman who has spent 2 decades in jail. The case of Kathleen Folbigg is one that has raised serious doubts and concerns, and it is our duty to ensure that justice is served. We understand that from the beginning Kathleen has maintained her innocence, and over years scientific evidence has emerged that supports her claims. Recent research has shed new light on the genetics of her family and that of her husband, suggesting that there may have been alternative explanations for the tragic deaths of her children. The initial guilty verdict was largely based on diary entries that were interpreted as admissions of guilt. However, there were significant issues with how this evidence was treated during the trial. The focus on these diary entries overshadowed the emerging scientific evidence that could have provided a different perspective on the case. In recent years, extensive scientific research has been conducted revealing the presence of genetic variants that could have contributed to the death of Kathleen's children. The findings suggested that the possibility of natural causes for these tragic losses. Prominent scientists and medical professionals have voiced their support for Kathleen, stating that there is a strong presumption that her children died of natural causes. Furthermore, the trial relied on discredited Meadows law, which suggested that multiple sudden infant deaths on one family were evidence of murder. Similar cases in other jurisdictions, such as the UK, have been overturned due to the flawed reasoning behind the law. It's crucial to recognise that justice should not only be about punishment, but also be about truth and fairness. Kathleen Folbigg has endured unimaginable grief and suffering as a mother who has lost her children. She has spent 2 decades in maximum security prisons, largely in confinement for her own safety. I urge all of those in this place to consider the growing scientific evidence and the bleeding obvious that Kathleen Folbigg may have been wrongly convicted. The Director of Public Prosecutions has said it is open for Mr Bathurst to find reasonable doubt. This is a huge moment. No longer does this state's top prosecutor maintain that Kathleen Folbigg is guilty. It's time for the Attorney-General to act. Has he called Tom Bathurst KC to see when the report will be handed down? I think it's also appropriate to draw a comparison here to the Lindy Chamberlain case. The counsel assisting with the inquiry and the DPP said that there was reasonable doubt. Yes, reasonable doubt. This was Kathleen Folbigg's matinee jacket moment. Lindy was released with a pardon within a week. Kathleen Folbigg remains in jail. Granting Kathleen her parole or a pardon would not only acknowledge the potential miscarriage of justice, but also allow her to reclaim her life and begin to heal from the immense pain she has endured. No one needs to be reminded that our justice system should be guided by truth, reason and compassion. It is our duty to ensure that Kathleen Folbigg receives a fair and just outcome, and as soon as possible.
The Minister. Mr Assistant Minister.
Thank you, Mr Assistant President. I represent the Attorney-General in this place, so thus will be representing the government in this debate. And at the outset, I just do want to acknowledge the presence of persons associated with Kathleen Folbigg. I'm sorry if I mispronounced the name. And at first instance, allow me to move that the question be amended as follows. 1, in paragraph 1D, omit "and the Director of Public Prosecutions" and meaning she was wrongly convicted. 2, in paragraph 1E, omit "grim." 3, in paragraphs 1F, omit "in the hands of the state and having been abused and bashed while held inside." 4, omit paragraphs 1G and 1H. 5, in paragraphs 2A, omit the words "Ms Folbigg's friends and supporters who and insert instead that a group of Ms Folbigg's friends and supporters." 6, omit paragraph 2B and insert instead B, "challenges faced by women in the justice system." 7, omit paragraph 3 and insert instead 3, that this House calls on the government to act in this matter appropriately as soon as practicable. Firstly, Mr Assistant President, the government is supportive of a constructive discussion with respect to the Kathleen Folbigg matter. The government is willing to support this motion in an amended form. I'm advised that the Folbigg matter is incredibly serious. In 2003, Ms Folbigg was convicted of the manslaughter of her first child, Caleb, the murders of further 3 children, Patrick, Sarah and Laura, and of maliciously inflicting grievous bodily harm on Patrick. Ms Folbigg was initially sentenced to 40 years imprisonment with a non-parole period of 30 years. On appeal, this was reduced to 30 years with a non-parole period of 25 years. Ms Folbigg has maintained her innocence, claiming the 4 children died of natural causes. The government acknowledges that there is significant community interest in this case. Legal and scientific discourse has been extensive and there are significant evidentiary complexities associated with this matter. The government is pleased by the progress of the most recent inquiry conducted by the Honourable Thomas Bassist, KC. In respect to the motion, I do wish to acknowledge the member who moved it and thank the member for raising this matter in this place. It is clear that the government has an imperative to act with care and diligence in this matter given the gravity of the circumstances. In May 2022, the former Attorney-General recommended the Governor establish a detailed inquiry process upon which this matter could be considered. The government is supportive of that course of action. The Folbigg matter has been subject to extensive judicial consideration. In 2005, Ms Folbigg appealed her convictions to the Court of Criminal Appeal. The appeal was dismissed. She made an application for special leave to appeal the decision in the High Court of Australia, which was also refused. In 2007, Ms Folbigg was granted leave to reopen her appeal in the Court of Criminal Appeal, and that appeal was also dismissed. Mr Assistant President, I seek the leave of the House to speak for an additional 2.5 minutes, given the matter.
Is leave granted? Yes. Leave is granted.
Thank you. In 2007, Ms Folbigg was granted leave to reopen her appeal in the Court of Criminal Appeal, and that appeal was dismissed. In February 21, Ms Folbigg applied to the Court of Appeal for judicial review of the findings of the first judicial inquiry regarding her case, seeking to have the report quashed or the findings in the report declared illegally flawed. The Court dismissed the application. It would not be prudent for the Attorney-General to make a determination with respect to the Folbigg case in advance of receiving advice or findings from the inquiry, given the previous extensive judicial consideration and the breadth of technical, scientific and legal evidence being considered. The government amendments to this motion reflect this position. The government, however, acknowledges that there is urgency. We wish to ensure that our amendments reflect the significance of this matter and provide assurance to all affected parties that the government has heard and is listening to these calls for actions and will work to make a determination on Ms Folbigg's application as soon as is practicable. The proper administration of justice is a central belief of the New South Wales Government. The Attorney-General will ensure that significant matters are dealt with proper diligence and proper consideration. We all agree that the rule of law is the bedrock foundation of our democratic system of government and must be upheld. To do so, we need to carefully and thoroughly consider the evidence and findings, and once received, the Attorney-General and the Government will do so promptly.
The Honourable Rod Roberts.
Thank you, Mr Assistant President. I rise on behalf of One Nation to indicate that we will not be supporting the motion as moved by Ms Sue Higginson, but if the government amendment is carried, we will support the amended motion. In 2003, Kathleen Folbigg was convicted of the murder of 3 of her children and the manslaughter of a 4th child. She was subsequently sentenced to 40 years imprisonment. Folbigg exercised her right of appeal. The conviction stood by her sentence and it was reduced, though, to 30 years with 25 years non-parole period. In 2019, following the petitioning by legal representatives for Ms Folbigg, His Honour Reg Blanche, AMKC, conducted an inquiry into the convictions. In his report, His Honour said, and I quote, "The investigations of the inquiry have produced evidence which reinforces Mrs Folbigg's guilt, and that he does not have any reasonable doubt as to the guilt of Kathleen Megan Folbigg for the offences of which he was convicted." During the Blanche inquiry, Folbigg was represented by senior counsel, and the inquiry heard expert evidence in relation to advances in forensic pathology, genetics, neurology, immunology and the understanding of SIDS since her trial in 2003. The inquiry heard from 16 expert witnesses. His Honour Judge Blanche, as indicated previously, could form no reasonable doubt as to the guilt of Folbigg. Fast forward to today, and we have yet another inquiry, this time conducted by former Chief Justice Tom Bathurst. This inquiry has heard from a number of experts. These experts have told the inquiry that Folbigg's daughters may have died as a result of a genetic mutation that may have caused cardiac arrhythmias, irregular heart rhythms and sudden unexpected death. But the experts are divided. Dr Dominic Abrams from the Centre for Cardiovascular Genetics at Boston's Children's Hospital gave evidence that said, whilst cardiac arrhythmias related to the genetic variant cannot be definitively excluded, I believe that the likelihood this was responsible for the deaths of Sarah and Laura is low. Remember that none of the evidence taken at the inquiry proves Kathleen Folbigg is innocent of the charges. It merely creates a reasonable doubt. So we have a conflict between the experts, something not unusual in the area of law. Now, notwithstanding that, there are many, including Ms Higginson, who is calling for the Attorney-General to advise the Governor to issue a pardon under Section 76 of the Crimes Appeal and Review Act 2001, or for the Governor to make a parole order under Section 160 AD of the Crimes Administration of Sentencing Act 1992. It's fundamentally wrong for the Parliament via the Executive to interfere with the judiciary. The rule of law and separation of powers should be maintained at all times. His Honour Tom Bathurst is a highly experienced jurist who will produce a thorough report. Once that report is completed and takes into account the totality of the evidence rather than snippets reported in the media, only then should the Attorney-General take the action that may be deemed appropriate. The law and its operation is not a plaything for members of Parliament. The judiciary only is charged with responsibility of the application of the law. They should be left unfettered to do their job without interference from the government. Their independence relies on it.
Further speakers, the Honourable Emma Hurst.
Thank you, Mr Assistant President. I rise on behalf of the Animal Justice Party to speak in support of this motion. In 2003, Kathleen Folbigg was convicted of 3 counts of murder and 1 count of manslaughter in relation to the deaths of 4 infant children, Caleb, Patrick, Sarah and Laura. She is currently serving a 30-year sentence in a maximum security prison. Despite decades of incarceration and intense public condemnation, Kathleen Folbigg has always maintained her innocence. Since 2021, more than 150 scientists have signed a petition calling for Ms Folbigg's release, which led to a 2022 judicial inquiry. It has been found that 2 of Ms Folbigg's daughters had a variant of the CALM2 gene, which often causes life-threatening cardiac arrhythmias, and her 2 boys carried a variant of a gene called BSN, which is associated with severe epilepsy and neurodevelopmental delay. In other words, it is likely that children died of natural causes. Both counsel assisting the inquiry and the Director of Public Prosecutions have concluded that based on the new evidence received, there is reasonable doubt about Kathleen Folbigg's conviction, meaning her conviction is no longer valid. A criminal case has to be proved beyond reasonable doubt. In light of the new evidence, that simply hasn't been met. It is devastating to think that someone could lose 4 children and be sent to jail for murder while innocent. No wrongfully convicted person should remain in our prisons. It is an enormous miscarriage of justice and one that should be rectified as soon as possible. While Ms Folbigg could potentially be pardoned or released via an inquiry process, there is significant uncertainty about how soon that can happen, and reports say that Ms Folbigg is not coping in incarceration. That is why we are supporting the motion calling on the government, and more specifically the Attorney-General, to issue advice to the Governor to pardon Kathleen Folbigg immediately. I also want to thank the member Sue Higgins for bringing this important matter to the House and for her work advocating for women who have been failed by this criminal justice system, and I commend the motion to the House.
The Honourable Ronnie Taylor.
Thank you very much, Mr President, and I also rise to speak on the motion, and I also want to thank Sue Higginson for bringing this motion forward and for her advocacy today. Mr President, there's been a lot mentioned on a lot of the legal, complications and challenges of this particular motion, and we have a lot of lawyers in this House, and I think I'm going to leave that bit to them as well, because I don't have a law degree. I want to say also commend the people in the gallery today. Tracy Chapman, Kathleen's lifelong friend and staunch advocate, what you have done for your friend, regardless of anything else, is so admirable, so courageous, and I really respect what you've done. I take my hat off to you. You are an amazing human being. It's been an absolute privilege to meet you today. Kathleen's lawyer, Rani Rego, is also here, and she's worked for Kathleen for 6 years pro bono. 6 years pro bono. A huge congratulations to you. That means a lot, and it is an amazing thing to be talented enough to have a law degree and to also be able to use that for the forces of good. Mr Assistant President, a lot has changed in 20 years, not just in technology and science, but also in our approach to mental health and treatment of women. Advances in science have allowed the legal system to understand precise natural causes of death for the Folbigg children. This new scientific evidence is vitally important, but it really is only one part of this story. In 2003 at the trial, a handful of words were cherry-picked from Kathleen Folbigg's diaries. Out of more than 50,000 words she wrote over 10 years, Mr Assistant President. There were no expert witnesses to analyse these diaries at the trial. The recent inquiry had 10 experts, which included 3 independent psychiatrists and psychologists engaged by the inquiry to review these diaries. They all shared the view that these diaries are not confessions of murder. As Sophie Callan SC, the lead counsel assisting the inquiry, said in written submissions, the weight of the evidence tends to suggest that Ms Folbigg was in general a loving and caring mother towards her children. At this inquiry, both counsel assisting and the DPP agreed that there is reasonable doubt about Kathleen Folbigg's convictions. As a society, we've come a long way in understanding mental health, PTSD, maternal grief, trauma and depression. These once stigmatised topics weren't largely discussed 2 decades ago, and they're certainly not discussed as openly as they are now. I think it's really important we reflect on this long case and we look at the treatment of this grieving mother. She didn't cry openly, Mr Assistant President, so therefore, in the public's eyes, she must have been guilty. But we now know trauma affects everybody differently. Not showing overt or public signs of grief doesn't mean someone doesn't feel the same loss as another person. It simply means, Mr Assistant President, that we all grieve differently. Kathleen Folbigg was grieving for the loss of her 4 babies. I respect that the Attorney-General has decided to... May I please have just another 30 seconds, Mr Assistant
Leave
President?
granted.
I respect that the Attorney-General has decided to wait for Tom Bathurst KC's report. But I do urge the Attorney-General to act immediately he receives the report and pardons Kathleen Folbigg, as every day in prison is a day too long. Mr President, thank you for the extension in time, and I also just wanted to give a very big shout out to a very amazing person in Bridget Glanville here today. Her history doesn't need anything exaggerated from me, but her advocacy in this case as well, pro bono, should be commended. Thank you very much.
Further speakers? The Honourable Stephen Lawrence.
President, I rise to speak in support of the amendment and the government position. I can hardly underestimate the significance of this issue. In my opinion, it's the most significant development in the criminal justice system in New South Wales in living memory. The horror of what we are dealing with here can also scarcely be understated. The horror of the death of 4 children, the horror of the prospect of the murder or manslaughter of children, the prospect of the death of 4 children by natural causes, and perhaps most importantly, in light of the concessions that have been made at the inquiry, the prospect of a person losing 4 children and then being wrongly convicted of the intentional homicides of those children. It's perhaps those horrors that make this case quite difficult to engage with on a human level, but engage with it needs to be done. The ancient powers that exist now, in part in statute, to parole or pardon are aspects of the prerogative of mercy. They are important powers, and the Chamberlain case shows how crucial it is that the repository of those powers always stands ready to exercise them, and it's relevant to